All right, everybody. Welcome to a very literally titled panel called A Conversation with Federal Judges About Federal Courts. My colleague, Professor Fallon, and I will spend about 45 minutes interrogating. I just want to make sure that's not me. No, but I'm putting myself on airplane mode right now. We're going to talk for about 45 minutes and ask some questions of this very distinguished panel, whom I'll introduce in a moment. And then we're going to open the floor for questions from you. And so, without further delay, I'm just going to say very brief introductions of the three judges we have, all of whom are from the D.C. Circuit. And I'm going to go in order of their seniority on the bench. So first is Judge Kavanaugh. Judge Kavanaugh went to the Yale Law School. No.
I've overcome it.
He clerked for Judge Stapleton on the Third Circuit and Judge Kaczynski on the Ninth Circuit. He spent a year as what's now called a Bristow Fellow in the Office of the Solicitor General. And then went to clerk for Justice Kennedy. After that, he's done a bunch of interesting jobs, too. He was an associate and a partner at Kirkland & Ellis. He was associate counsel in the Office of Independent Counsel Ken Starr. He was an assistant to the president and staff secretary and an associate counsel to the president during the Bush 43 administration. And he's been a circuit judge since 2006. Really? Wow, time really flies. Okay. And next is Judge Pillard. Judge Pillard graduated from this law school in 1987 and clerked for Judge Pollack on the Eastern District of Pennsylvania. She was a Marvin Karpotkin Fellow at the ACLU, and then assistant counsel at the NAACP Legal Defense and Education Fund. She was then an assistant to the Solicitor General, and I should say I've worked with both Judge Kavanaugh and Judge Pillard in the Solicitor General's office at different times. And then she was a professor at Georgetown Law School and briefly a couple of years as a deputy assistant attorney general in the Office of Legal Counsel during the Clinton administration. And Judge Pillard has been on the bench since December of 2013. And then Judge Wilkins. Judge Wilkins is also a graduate of this law school class of 1989. He clerked for Judge Gilliam on the Southern District of California, and then went to be a public defender in the District of Columbia for a dozen years, at which point he went to join the law firm of Venable LLP. Judge Wilkins was the lead plaintiff in a case called Wilkins versus State of Maryland, which is a landmark civil rights case that has inspired nationwide reform of police stop and search practices. He's also been a key player in the establishment of the Smithsonian National Museum of African American History and Culture. And we're delighted to have all three. Oh, and he's been on the D.C. Circuit since January of 2014. So you both joined very close after each other. Okay, there you go.
Don't minimize it. I'm 2 weeks senior.
She never lets me forget it.
And we're delighted to have all three of them here. This very, very distinguished panel, and we're gonna start by asking some questions. So, Professor Fallon, you have seniority over me.
Yes, I do.
Would you like to ask the first question?
I would be thrilled to ask the first question. I've been thinking hard to get something to really stump them. And so I would like to ask, what's it like to be a federal judge? We sit here and we teach judges' opinions, but I think most of us, and students study them, but I think most of us don't have much of an idea of what it's like to go to work in the morning, what you do, how many cases you're dealing with at a time, how often you hear arguments, whatever you think is interesting and informative along those lines.
I'll start. I guess seniority
means something. First of all, thanks to Dean Manning and Professor Fallon and all of you for being here. The reason I think I was able to crash this pad is because I've taught here for the last 10 years as a Harvard professor, and many former students are here. And so thanks to Dean Manning for allowing me to be part of this panel. In terms of, even despite my school that I attended, so on a daily basis, on a regular basis, what's it like to be a federal judge? We appellate judges, much different from trial judges. Judge Wilkins had been a trial judge, federal district judge before. I had not. It's very different experiences, as he can talk about. For me, and for all of us now, we read a lot of briefs, and there's a ton of reading of briefs of difficult cases. Our court is distinctive for its administrative law docket, so a lot of regulatory cases, important regulatory cases, a lot of statutory interpretation, occasional constitutional separation of powers kinds of issues, but it is a lot of reading, and then it's a lot of writing. We have to write, we hear oral argument, which is my favorite, actually, part of the job. I love oral argument. Then we write our opinions, and writing is pain. Writing is pain, as Justice Scalia used to say. You know, people said to Justice Scalia, "Oh, you must love writing, Justice Scalia. You're such a stylist." And he'd say, "I hate writing. It's painful. It hurts, and it does hurt. It's hard, but you love having written. You love having written." And that's part of our jobs on a regular basis. So at any given point on a day, to your question, I'll be reading some briefs, I'll be working on some opinions or an opinion, and I'll probably be responding to another opinion. So those are kind of the three things I'll be doing at once: reading briefs for the next oral argument, working on opinion, responding.
But just as a concerned taxpayer now, to make sure you're working hard enough, yes. How many cases at a time are you dealing with? How many cases in a month or a year, or some framework that would give us a ballpark sense of what you do?
Go for Pillard on the statistics. I would say that in a year, each of us is probably hearing something between 60 and 80 cases. Higher. It's higher than that. 100 cases, maybe.
Yeah.
I think that I, in the past few years, have written probably over 20 opinions in a year. But I would have to take issue with the unit measurement, because if you compare the D.C. Circuit with some of the other courts of appeals, with I think any other court of appeals around the country, our case numbers are way lower, and we have a very different caseload. And when I was a student and looking at clerkships, I had no idea how different the caseloads were. The D.C. Circuit is very distinctive in that we get cases against the government, cases dealing with big regulatory records. I remember when I first walked in to my chambers, one case had a record that was stacked on the floor, up to my waist. And a lot of the case volume in the other circuits we don't have. We don't have a prison, so we don't have prisoner cases. We don't have immigration cases in our court. So a lot of the high volume sort of individual cases, sometimes the cases where they're pretty much legally foreclosed or legally the questions are more routine, we just don't have that whole volume of work. We also have in the D.C. Circuit, and it's interesting to me how ununiform not only the nature of the substantive dockets, but also the way the circuits are managed varies greatly from court to court. And we do have a permanent legal staff that helps to sort of sort cases so that there are some that can be dealt with on a sort of more summary basis, and those are not among the ones that we would be dealing with briefing and argument. We deal with them, but we deal with them on a more summary basis, on a more routine basis.
So I can give you a little bit of a perspective of what it's like both to be a district court judge and a court of appeals judge, because it's very different. My life as a district court judge was much more unpredictable. Because as I drove in to work that day, I didn't know whether I might get a TRO or whether there might be some sort of a discovery dispute or a motion to compel or some sort of emergency that might arise that I had to deal with. And that made the job kind of fun because, you just, nothing was rote. But the thing that I didn't really understand until I went on the bench as a district judge is how much of a manager you have to be as a U.S. District Court judge, because you've got to manage your docket. You've got to get that case, the civil cases, from complaint filing to disposition, whether it's going to be resolved by a dispositive motion or by trial or by settlement. You've got to move that case along, and the case doesn't really always just move itself. So that was a part of the job that I thought that I would really not like when I started dealing with this civil docket and keeping up. But I actually ended up really liking that part of the job, because I got some satisfaction from, seeing a complaint getting filed, and then I would read it to just make sure that there was no conflict issue or a recusal issue for me. And I might read the complaint and say, oh, it's a very interesting complaint. I wonder if he's going to be able to prove any of that, And then, 16 months later or whatever, presiding over the trial of that complaint and seeing the jury render its verdict, and then feeling like, wow, I helped that case, move from beginning to end, and was intimately involved in all of the things that happened along the way. In the Court of Appeals, it's much more, we're dealing with an issue, and we decide that issue, and we send it back to the agency or the court below, or we dismiss it, and we don't know what happens after that, and it's all very much more antiseptic. We deal with the issue, and we don't really know or have a sense of the parties or what the resolution of anything is.
So Professor Fallon and I both were law clerks on the D.C. Circuit, and it's, of course, it's in the nation's capital, and so it's the seat of government, and so you get a lot of government cases, and that's one of the things that makes the court distinctive from other circuits. And so we were kind of curious, in this day and age, what percentage of your cases would you say are constitutional cases? What percentage are statutory cases? And we're going to, I think, include in statutory cases, and if you want to disaggregate it, you can, the kind of APA-style cases. So how does it all break down for you all?
This is guesswork because it fluctuates and changes over time, but maybe 10% constitutional cases, a lot of statutory interpretation, and I don't think I can really disaggregate the statutory interpretation from the APA-style cases, because usually you'll get a claim that what the agency did contravened a statute and at the same time was arbitrary and capricious, or if not a violation of the statute, was arbitrary and capricious. So those are usually mixed together, and that's a good 50, 60, 70% of our docket, I think. We get some just civil disputes that don't involve the government, not a ton, frankly, but we get some of those cases. And then we have a criminal docket that's been shrinking over my time on the court, in part because there's less crime in the District of Columbia, which is a good thing, in part because more cases are being brought in the local courts of the District of Columbia, given the unique dual jurisdiction of the District of Columbia. We've just had a lighter criminal docket, also in part because sentencing guidelines cases are far fewer than they were when I started in the wake of Booker, and the sentencing regime being more discretionary now than it was under the sentencing guidelines. So that's, I think, the basic breakdown.
I mean, that's another area in which we're a real outlier. I think that our, if I recall correctly, recent annual statistic for criminal cases was it was only 6% of our docket, and that's far below. The U.S. attorney in D.C. can prosecute either in the D.C. court system or in the federal court system. So it's it's very unique in that sense. So most federal judges around the country are doing a lot of criminal work. We're not. That said, I would say a big chunk of our actual constitutional issues are ones that come up in the criminal procedure context, whether they're, Fourth Amendment or issues about, notice and charging. And we don't have a lot of constitutional cases. I would say the other issue, and I don't know if Brett would even include these in his breakdown, but I think the most common constitutional issue that we see is standing, which we see a lot of tricky standing issues, just a huge number of questions about...
A lot of frivolous ones, too.
Yeah. Well, sometimes he finds standing, and I tried to convince him it was frivolous.
No,
but,
I mean, I meant that even-handedly. They're just, it's raised quite a bit by the government, even when...
When there clearly is standing.
When there clearly is standing.
I mean, it's a tough area. I don't think either of my colleagues here would deny that's a tough area. And we get very few diversity cases. We do get them, but, which are going to be a case that has a contract dispute, some major construction, or I guess I've had a few that were construction-related issues, but not very many.
We don't get a lot, but we have a fair number of employment-related cases, Title VII cases, or other employment-related cases. Not a lot, but a significant number.
I agree with that, a large number, usually from a government agency, discrimination in a government agency, an allegation of that.
And what about, so the way I think about your court, it seems to me you get a lot of national security and separation of powers cases. Is that right, or does it not feel that way to you, or are they just high salience cases?
Well, numbers-wise, it's probably not a huge number, but when they come, they're big and they occupy a lot of time. So in terms of time and effort, because they're usually huge cases, so the national security docket when I started was enormous because we were dealing with the Guantanamo aftermath, the aftermath of Boumediene, which for our court, that was a huge 3 or 4 year effort following the district courts, who also had a huge effort. We kind of made it through that in one piece, I would say. I'm proud of how the courts handled that and got through it. But that part of the docket's not gone, but it's dropped off significantly. But we still have a lot of national security cases, as you say, separation of powers cases of a lot of kinds. We have a lot of First Amendment cases, I think more than I would have anticipated when I went on the court, all sorts of First Amendment claims, again, with the government being there, people in the First Amendment, free speech claims, and some religion, but a lot of free speech claims.
So if that's what your docket's like, and I certainly find this fascinating, which kinds of cases keep you up at night, if any, do? Does it vary with subject area, or is it something just peculiar to the case?
The one I'm working on now. I mean, you try to focus on each case and give it your all. That's one of the important things about our job, I think, is to treat them all as important, because they're all important to the people who are affected by it. They all can be important for the government agencies. Obviously, some are more difficult than others. Some kinds of questions, for me at least, are more difficult than others. A lot of our cases will come, the Supreme Court precedent is not exactly on point. If it were exactly on point, it wouldn't be hard. But you have to interpret the scope of a Supreme Court precedent, very challenging at times, and the scope of a prior precedent of our court, also very challenging at times. And I'm huge on vertical stare decisis in letter and in spirit, and also horizontal stare decisis to prior panels in letter and in spirit, and I know my colleagues are too. But saying that is easy. Actually doing that in a particular case and trying to figure out what the Supreme Court said and meant, or what a prior panel did, it can be very hard. So those are some of, that's something that recurs for me a lot, and I would identify as something very challenging for me.
I mean, I would really second what Brett says about, the cases that keep you up at night are the ones you're working on at the time. And it's funny because, the way the press covers it, they cover only a very select, small group of the cases. They tend to be the cases that are the most politically polarized. They tend to be cases that don't really represent the full depth of all the different things that we work on. But I would say that that we're really dealing with precedent more than with, let's say, the Constitution simpliciter. I mean, one of the questions sort of one thinks about when one's going to be asked about judging is, what's your theory of the Constitution, or your theory of statutory interpretation?
That's coming.
That's coming, yeah. And let me just say, as a presage to that cases don't think I've had a case yet that really called on me to figure out the answer to that question. It's just not the way the issues are served out.
Judge Wilkins, what?
So it's interesting, answering the question about what keeps me up at night. When I was a law clerk for my judge on the U.S. District Court in California, we had this case that I was struggling with what to recommend to do to the judge, and I went and talked to him, and then he suggested I research something else, and I kind of went back and forth 2 or 3 times, and ultimately said, well, Robert, we've talked this through, and this is the way I want to decide it, so I want you to draft something up along these lines. And he concluded by saying, I'm a United States District Judge. The American people pay me to make decisions. They pay the Ninth Circuit to get it right. What I took from that conversation, especially when I went on the district court, was that of course you're trying to get it right, and Judge Gillum always was very diligent about wanting to try to find the right answer, but you had to kind of balance that against just moving your docket, and there was this fail-safe, the Court of Appeals, that if you screwed something up, whatever, then they would fix it, and your decisions weren't precedential. A decision in the FSUP doesn't bind anyone anywhere. So,
Except, importantly, the parties.
Yeah, the parties. So I guess I took some solace from that, and then when I went on to the D.C. Circuit, then I realized, oh shoot, I've got to get it right now. So now I'm staying up late at night a lot more, thinking about my cases.
The other kind of case that I would identify as particularly challenging, as I thought about this, kind of recurring cases, not just interpreting precedent, but then our statutory cases. Statutory interpretation is such a large part of what we're doing, even if it's in a regulatory context. And statutory interpretation has improved dramatically, in my view, over the last generation, but there's still, if the text is clear, follow the text. Okay, we all got that, but there's a lot of times, is the text really that clear, and how do you determine whether the text is ambiguous? This is something I've obsessed about for the last few years, about how can 2 judges agree on whether something is clear or ambiguous in the first place. That's actually an unbelievably challenging question, but it affects the resolution of our Chevron kind of cases and a number of other kinds of cases. And then the canons of construction that you resort to in statutory cases, there's a lot of debate about which canons apply at which times, what's the trigger for a canon, what if you have 2 conflicting canons. So that statutory interpretation is still quite challenging to me, and I think we all agree now, if the text is that clear, okay, that's it, but there's a lot of challenges that are in the cases at the margins, and most of the cases we get are at the margins of that. So that's a recurring challenge as well for me.
So this leads to another question, and it's, I guess I'd say on a scale of 1 to 10. So let's start this end and go that way. On a scale of 1 to 10, how much do you love Chevron? Judge Wilkins?
I'm going to need a bigger boat.
Love is a strong word. I guess, I guess I haven't thought about it because I guess, as a member of an inferior court, it doesn't matter whether I love it or not. It's the law of the land, and I'm stuck with it. So I haven't really given it much thought. I mean, I've heard conversations and then been in, debates with some of my colleagues about Chevron in its wisdom or logic or lack thereof. But I don't have any major problems with Chevron. I guess I would say a 7.
So I agree, of course, it's binding law of the land, but the logic of Chevron became clear to me. As I mentioned, I came into my chambers and found case files that reached up to my waist, and really also not just administrative records, but entire statutory schemes that I had not studied in law school and that were not familiar to me. So the learning curve is steep. That's what keeps us up at night. And also, it's the most stimulating thing. The docket is fantastic. It's so interesting. And even when the legal issue is yet another Chevron issue, it's on a different factual background. It's, this is how they decide where to drill on the outer continental land shelf. This is how the wireless spectrum is allocated among different businesses that are trying to offer you broadband. This is how medical devices get cleared for marketing, as science is developing really, really interesting, amazing stuff. And I am a big believer in understanding the real world facts about what the agency's grappling with, what is the science claiming here, what's it doing, what's the economics claiming here, what's it doing. At the end of the day, though, I'm not the de novo decision maker about which filters are, appropriate to achieve X level of, clean air in such and such an industry. Of course we have Chevron, because there are teams of, hundreds, if not thousands, of specialist lawyers and scientists who have, and policymakers who have made judgments, and they bring it to us for a relatively shallower dive to figure out whether they are fulfilling their responsibility under their statute and fulfilling their explanatory responsibility, their responsibility to consider all the different perspectives. So it's a little bit hard to imagine a system of courts that doesn't include, lots of PhD scientists somewhere on a staff that could operate without it.
Yeah, I clerked for the year after Chevron was decided, and by the middle of the year, my judge was using it as a verb. John, can't we just Chevron this thing? Judge Kavanaugh?
I'm sure there was Chevron before there was Chevron, though.
Right. So I'll give you a few different pieces of this as quickly as I can. If a statute says a term like reasonable, feasible, appropriate, practicable, I'm in full agreement with what Judge Pillard, with what Nina just said in terms of that's not really our job to second guess, other than to making sure they stayed within some bounds. I really view that as much the State Farm Doctrine as the Chevron Doctrine, really in application, and I'm tight. I describe myself as pretty tight on pushing agencies on their statutory interpretation. I think I'm pretty deferential on their policy choices. Of course, a lot of cases, that is the question, is this the statute or a policy choice? But that's how I think of myself. But when on applying Chevron in terms of its clarity, yes, it's precedent, so we apply it, but there are two aspects of it that are very challenging. One, right now, there's a major questions doctrine exception, sort of, to Chevron that the Supreme Court, in my view, has articulated. What does that cover? When does that apply? That's, for me, a real challenge. I've had cases where I've written about that. Secondly, and this piggybacks on a point I made a minute ago, you only defer to the agency if the statute's ambiguous. If the statute is clear, you decide the meaning of the statute, and if the agency has not corresponded to that, then the agency loses the case. Well, that raises the question, is the statutory term ambiguous or clear? And that, I'm telling you, is a debate that there's no objective standard for. Is certain language ambiguous or clear? Where's the trigger? Is it 80-20 clear, 60-40 clear? What is the appropriate trigger to defer? And then let's just say we agree.
60-40. No, sorry.
Okay. Let's just say it's 70-30.
Your next article.
Let's say if it's 70-30 clear, then it's clear. Otherwise, it's ambiguous, defer to the agency, or other way around. And how do you apply that to a particular set of facts, to a particular statutory interpretation? That is a very, very challenging issue on which two people who are conscientious judges trying to do the best they can and trying to be the judge's umpire to the nth degree will still disagree. And that's important because those cases, that one trigger, is it clear or ambiguous, could affect the fate of clean air regulations, billions of dollars, and I'm not exaggerating, billions of dollars, securities regulations. That one question, is it clear or is it ambiguous? Because if it's ambiguous, the agency's going to win. If it's clear, the agency's going to lose, say, in a particular case. That's an unbelievably difficult thing, and it's a problem, I think, in the Chevron doctrine, a real chink in the armor, to use a phrase Justice Scalia once said. I'll mention two other very quick points about Chevron. One is, having worked for 5.5 years in the White House, knowing that you can get away with things in the courts incentivizes the executive branch to push the envelope on statutory interpretation. You run for office through the snows of Iowa and New Hampshire for policy, not saying, when I get in, we're just going to follow the law. No president runs for office on that. They're saying, we're going to do clean air, we're going to fix the immigration system. When you get in, you have a statutory scheme that constrains you, but you say, well, can't we just say it's ambiguous and push the envelope and see what the courts say? This is a big shift of power, kind of a judicially orchestrated shift of power from the legislative branch to the executive branch, and I've seen it firsthand. It incentivizes the executive branch to really push the envelope on its policies and then to backfill trying to fit it into the statutory scheme. I'll stop there. So those are issues about Chevron. It is precedent. I apply it. Even as precedent, it has murky issues. And then the real-world impacts, it's a big shift of power to the executive branch.
I would say also, even if we could say, 70-30, 40-60 level of clarity is enough for something to be clear, we all have experienced that the terrain, it depends to some extent what kind of issue you're talking about. Is the issue an issue that's relatively more sort of accessible to judges? Or is it an issue that really is, the very question of clarity or not is going to be something that a specialist is going to have a better ability to get a handle on? And so, I think you couldn't overemphasize enough what difficulties that poses. And then, so that if something is more judge-like, we're going to be have a little bit more hubris about saying, it's something we can have access to. We're not going to defer. Whereas if it's something that really is in the heartland of the agency's expertise, and they appear to be using their expertise, it's going to be something more comfortable.
So if my dean, with whom I want to stay in good, were asking the next question, I'm sure it would be on a scale of 1 to 10, how do you rate textualism? But instead of taking it that squarely head on, I would angle into it slightly differently by way of something like a judicial philosophy. So Judge Pillard, you said at one point, I'm sorry, Judge Pillard. You said she was my student. This is how clever I am. It's taken me 30 years, and I still don't get it right. You said at one point that you don't have any need for a grand theory of the Constitution. That doesn't come up. Do you need a grand theory of statutory interpretation? Or even, is it possible that you don't have either a grand theory of the Constitution or a grand theory of statutory interpretation, but you still have something you might call your judicial philosophy? I
would say it's very circumstantial. I don't have a grand theory of statutory interpretation either, and that may partly be that I don't have enough years of experience to have enough salient repeat cases to sort of build up a sense of, like, in this category case, I'm coming out this way. I would say on the textualism front, everybody agrees that we follow the text. Everybody agrees that there are canons, tools, structure is high up there. That there's sort of a hierarchy of tools that we use, and I think one of the most important lessons that the new textualism has brought on is to appreciate that we don't go straight to purpose in some broad sense. This is environmental law, or this is labor law, therefore the purpose is to protect unionization. Therefore, I'm going to read it broadly in light of that purpose, because, as everybody knows, legislation is a compromise, and the purpose was achieved, but only up to only in as far as the purpose was achieved. And if the language isn't better for the party in whose interest the legislation was putatively adopted, well, then it's not better language. But so sometimes you can identify that there's it's plausible that the text isn't clear for that kind of reason. And then there are other cases where that's not what is being manifest in language that is unclear. So I think it's again, there are sort of particular theories that are very helpful, that, some of them produced from this very law school, that are very helpful to us in particular cases. But I guess I'm just not sure that there's that much controversy among my colleagues about the available tools, about the fact that, each rule has certain cases where it breaks down, and then we do have difficult judgments about which extra canons do we draw on and why is one more appropriate. But I do really resist the idea, partly because it's just not my experience, that it is very helpful to me to have, and I was an academic, so you'd think if anybody's going to come in with, grand theory, I was an academic before I became a judge, and I did teach constitutional law and statutory courses as well, but it's just, that's not what I'm sitting around thinking about most of the time. It's really getting the answer right and learning a lot about both the law and the real world setting.
Judge Wilkins?
I think that one question that's a vexing one that I think impacts probably subconsciously all of us as judges in thinking about statutory interpretation and textualism is really, I guess, what prior experience perhaps we have or we don't have with Congress and actually seeing how the sausage is made. Because depending upon kind of your framework there and your experience, I think different judges, expect Congress to have really be super clear about something because, they should write a sentence the way I would write a sentence. But, the kind of the hurly-burly of legislative decision-making and drafting isn't, necessarily the same as, the way that we operate in a judicial chambers. I think also, people's thoughts about these things might vary depending upon how easy they think it is for Congress to correct something. Well, if we say that the statute doesn't really cover this and Congress really wanted it to cover it, then they can fix it because they can just, pass a law in next year changing the language and adding it back. Well, if your view of that possibility, differs on how well you think Congress functions or not, or whether the Congress now kind of is in the same place as it was then, as far as its mindset and making this a priority or its views on this issue. And so I think all of those things probably, we're human, I think all those things subconsciously, affect how we look at statutes and define, whether something is clear or whether we're going to require Congress to be, really clear as opposed to 70% clear or something on an issue.
I think first and foremost is precedent. If there's a statutory precedent from the Supreme Court on point and that reaches a result that you don't think is a textualist result, that doesn't matter. You follow the precedent of the Supreme Court on the issue in question. If there's not a precedent from our court that binds us or from the Supreme Court, I am a textualist, as Justice Kagan said here a year ago. We're all textualists now in many respects, and I think of that for both formalist and functionalist reasons. As a formal matter, the law is what's written in the statute. As a functional matter, as Robert just pointed out, the law is a compromise, and no law is written by one person. And so inevitably the law may look like it's got conflicting points, or it may not be the way you would have written it, but it is a compromise, and Dean Manning's, of course, written the most and been so influential on this topic, but you upset the compromise that Congress struck if you don't stick to the words that are actually written in the statute. But to say you're a textualist really still leaves a lot of tough cases, because what if the text, as I said before, is ambiguous and the canons kick in? Then there's a lot of debate about whether it's ambiguous and what canons to apply as well. The other thing I'd say about textualism right now, and one of the big things I know Dean Manning is focused on and others, is interpreting the text in light of the context. That's a big thing right now. To what extent does the context show that the literal words of the text might not actually mean what they exactly say because of the broader context? I think what exactly that means in practice is a little bit of a debate right now in particular cases, and something to keep your eye on. And to Robert's point, the Congress can always fix it thing. To my mind, judges do say that sometimes in court, in oral arguments, sometimes in conference. It's not a neutral principle based on our separation of powers system, which makes it much harder, of course, to pass legislation than it does to block legislation. It takes the House, the Senate, and the President to pass legislation. The framers wanted it to be hard to pass legislation, and it is hard to pass legislation, as we all experience every day. That was the system they designed. So to just say, well, I'll go with A rather than B, Congress can always fix it, is really not a neutral principle at all, given our broader separation of powers system.
So I want to follow up on something that you just said. So, you've said in this set of remarks and in some earlier ones, sometimes you're bound by what the Supreme Court says. You believe in horizontal stare decisis. Sometimes you're bound by what your court has said. Sometimes you feel bound by the text when the text is clear. But then, there are those times when you're not bound. So you're not bound by the text. You're not bound by precedent. You're not bound by horizontal precedent, vertical precedent. And ultimately, you have discretion. And so when you have discretion, how conscious are you of exercising a policymaking function?
Right. So that's a great question. There's always this debate, is it all law like you're robots, or is it all common law, just do what you want as a judge? And like most either-or questions, it's a false question, because there are a lot of cases, as we've been discussing, where I think you've got to follow the precedent, you've got to follow the statute as written, and that's our job as judges. Balls and strikes. Judges umpire, not a lot of discretion. There are cases where the statute itself may, or the Constitution itself, may give the judges discretion. Just Rule 501 of the Federal Rules of Evidence, create privileges in light of reason and experience. That's just a broad grant of discretion to the courts. Unreasonable searches and seizures. There's no code book you can look to say, okay, give me the list of unreasonable searches and seizures. That's going to be based in practice on your experience, on the precedent. You're going to be exercising a common law-like power in a case like that. There's going to be judicial discretion. What is good cause? There are a lot of statutes that have good cause exceptions. What constitutes good cause? You're going to be developing a body of common law-like exceptions that fit within the statute. It's not that you're ignoring the statute, it's that the statute grants to the judge in those cases, I think, a common law-like power. And so in those cases, what are you trying to do? I say that you're still trying to be the judge's umpire, in my view, and what that means is being consistent, being prudent, explaining your reasons, developing a coherent body of common law-like decisions that make some sense. But you do have more discretion in those cases, undoubtedly, just as umpires in baseball, when there's a play not covered by the rules, have more discretion. Like when the Washington Nationals got ripped off in Game 5 by the call, the bat hit the catcher's mask, the play was dead. Anyway, sorry. I'm still very bitter about Game 5 of the Nats playoff series.
We can all get riled up over that one.
You're hiding it well. Judge Pillard, how about you? When you have discretion, are you conscious that you've got a policy-making function?
Yes, but I think that Brett's use of the term common law, common law like is really apt. I think a lot of the times when we're doing that, it feels very guided. But I would also say that I think there's a kind of diversity on the bench that is underappreciated, and we talk about diversity in terms of gender diversity and racial diversity and religious diversity, but I think a really important kind of diversity is the prior experiences that you've had in life and as a lawyer. And we have a really, really stupendous diversity of experience among the judges on our court, people who have done specialized regulatory work in energy law and antitrust law, people who've been in White House counsel, who've been in criminal law, prosecutors, defense lawyers, people who've worked in big firms and smaller firms, academics. I mean, just a really, really wide range. Not so present on the federal courts are people who have represented plaintiffs. And it's one of the things that we all bring when we're thinking, is this result sensible? Is this result workable? Is this result something that is going to facilitate the fair resolution of not only this case, but future cases? And I think that we just have a real resource in sharing our intuitions about fairness in light of the really very multiple and deep past experiences that we have. And in light of that, I just would note one of the things that struck me when I came on the bench was how little hobnobbing we do outside of conference. I was deep into preparing my first several cases, and I thought, gosh, I'd really like to talk to the other judges who are deep in the same process. And people don't really do that in our building. And over time, I've really come to appreciate and embrace that. And that's really for two reasons. One is sort of an obvious reason that, am I going to call up both of the other people that are on the panel and talk to them? And if it's a little awkward and formal, and if I'm not, then how would I feel if the other two judges on that panel were talking about it without me? There's something a little awkward about that. But much more importantly, it's that each of us independently comes to our own best judgment of what we think the case, how we think the case should be decided. And then we come together and engage. And we've really gone, all the way to sort of, if I had to decide this alone, where would I be? And then we come together. And that is, I just think, such, when you mentioned the taxpayer before, such value added for the taxpayer. It is, you would be astounded, I think, if you realized how many, judges who are appointed by the same party, presidents of the same party, come together and how differently they see cases, and just how much, work we do in figuring out where to go with the different contributions that we bring to that table. It's really, one of the tools we have in dealing with these very difficult and quite momentous issues where the sort of authoritative guidance does eventually run out.
Judge Wilkins?
I think that probably the hardest cases are the ones where, we kind of explicitly have a lot of discretion, because then, really then we have to figure out how to use it and how to define, what is reasonable, what is a good cause, or what is, what should be the bounds of a privilege or something of that nature, because then the task is really trying to figure out how to see down the road and around the corner and years ahead of how, if you articulate it this way, how is that going to be used? And how is some, very smart lawyer coming from, this law school or some other fine institution going to, take this, perhaps this one sentence and this one nugget and then run with it, and where will that go? So those are the cases, that I think are the most challenging for that reason.
Yeah, there are cases that, if you're a real textualist, the Religious Freedom Restoration Act talks about compelling government interests. That's what it says. Okay, so I read it, it says compelling government interests. But what are the what are acceptable compelling government interests? There's no code book that lists those when you're interpreting something like that statute, which is so important. And there are lots of statutes that have things like that in them. So it becomes very, very hard. And then your policy views, your views of fairness don't trump the statutory text, but when you're explicitly told by Congress that it's the judge is making the determination of what's reasonable, you need to do that. But if you're just following the text and you think it's unfair, this is to something Nina said, you say that. And I think in my opinions, I always try to say, I realize this may be seen as creating problems or there should be a fix here, but this is the way we read the statute as written. And to something Robert said about workability, that's a critical part of our opinion writing. That always keeps me up at night. Fear really keeps me up at night, which is the fear of writing an opinion that is, I think, beautiful opinion and is not workable in the real world of the agencies, the people who have to apply this. So getting it wrong keeps me up at night, but also doing something where someone says they didn't get it. That's a huge fear of mine when I'm writing an opinion. I work really hard to follow on Robert's point of explaining as clearly as possible so that it will be workable, identifying the flaws if there are that we can't fix, but also explaining how it should work in the real world. That's a hard part of the job, I think.
Okay, with fear having emerged as a central motivation here, I have 17 more questions I would like to ask, but I'm afraid of what would happen to me if I tried to do that. And so I think it is time to go to the audience and see what some of our distinguished participants here have to ask about. And so, do I have to choose?
Yes.
I saw this gentleman's hand first, and then there are some other hands over here.
Yeah, Justice Pillard stated that...
Can you get your microphone on there?
Okay. Justice Pillard stated that you folks don't really hobnob, brainstorm other than in conference. Do your clerks do it? What happens if after the conference you're in charge of writing the majority opinion and it's 2-1 case? How does somebody communicate that paragraph 15 is going to cause her to flip? Your clerks communicate or what?
It's really a surprisingly formal process. Sometimes we do talk, we conference. And conferences last from, in my experience, I would say on the very short end, maybe 10 minutes for 3 cases to 3.5 hours, 4 hours. It really depends on how important the case is, how hard it seems, how much we're coming, with very different perspectives, how motivated we are, frankly. I mean, I have colleagues every colleague is dedicated, unbelievably able. I mean, the longer I work with these people, the more respect I have for the abilities of all of my colleagues. People have different levels of patience and appetite for working through things together.
It's a human institution.
It's a human institution. But what we'll do is we'll conference and we'll try to resolve, at least in gross form, what each element of an opinion is how it's coming out. And if a judge has strong feelings about, I do not want to rely on ground A, let's do it on ground A prime, they will say it in the conference. And we all take notes. The senior judge at that conference who's presiding will then circulate what we call a disposition memo. And I think it's a relatively, they're trending to being a little bit more meaty, those disposition memos, but still we're talking a couple sentences to a paragraph, very, very short, but just for just those reasons, so that the person who's drafting the opinion doesn't go stumble into a hornet's nest that then makes the whole majority fall apart. But then we circulate a draft opinion just among those panel members, and we have an online system for doing that, and you're supposed to drop everything else you're doing, and within 5 days, that's calendar days, including weekends, you're supposed to get back to your colleague on their draft opinion, and that all happens before it gets then circulated for 7 days to the full court, before it goes out to the public. So there are these sort of two-stage process. Then the panel process is can be a very engaged process, and then the full court circulation is really just so that we know one another's work more or less before it goes to the public. Although you can look at a panel opinion and tell a colleague on a panel that you didn't serve on, hey, when they petition for en banc, I'm planning to vote for en banc. I think you got that really wrong. Courtesy? Some might think that's
courtesy. Yeah. Candor.
But there, again, the range. Sometimes an opinion comes around and the other two judges say, great. Sometimes an opinion comes around and, I had one that I thought I'd written in a very plain vanilla way, and it was going to be one joining me and one dissent. And the judge who was joining me said, that sounds to me so tendentious, I can't join it. And I thought, wow, I thought I wrote a really plain vanilla opinion, but that's tendentious. What are you referring to? And the judge told me, well, you described the standard in this way, as a miscarriage of justice. So, well, that was actually just quoting the Supreme Court. But, the tone to my ear was very sort of flat, and to this other judge's ear sounded like we were condemning the district judge. And I rewrote the whole opinion and satisfied my colleague, and so that's a process that can be more labor intensive, can be less. It's critically important to the legitimacy of the opinions that we issue. And I also would say you can quickly imagine it generates typically narrower opinions. If you're going to try to keep everybody on board, and if everybody feels that they have to be on board in order to sign off, then you're going narrower. And I tend to think that is a good thing. I know we have a history of lauding certain, judges who write in grand terms, but I really appreciate that we are not omniscient, that we are deciding the cases before us, and we do a responsible and sound job when we kind of stick to the case by case.
On the hobnobbing point, I just want to say the reason we don't hobnob before oral argument is what, in my view, is exactly what Nina said, which is we want three independent voices coming into oral argument. Groupthink can develop quickly if you converse before oral argument, if one person's prepared more than another than the other two. That sounds good, and then you really haven't all three prepared independently. After oral argument, the conference, but even after that, there isn't human in-person hobnobbing as much, but if you think of texting and emailing as the modern equivalent of hobnobbing, there is a ton of hobnobbing in terms of our written communication in a lot of cases back and forth. It's not person-to-person as much as it might have once been.
There's a lot, and we have a special dedicated place where you post things, your comments on someone's draft, and they go to all three, so that, if the three of us are sitting together and Robert circulates an opinion and I have comments on it, I can give them to him within that 5-day window. And then Brett can see what I've said, and he can say, well, I agree with Pillard on 1, 2, and 3, but actually I would go absolutely the other way on 4, and then dear Robert has to figure out how he's going to make us both happy. And I would also say we have one of the things about it being a human institution is sort of figuring out the culture, but also helping the culture grow. When I came on, I told you I came from academia, and when you're reading colleagues' work, you're not doing your job if you don't give colleagues a lot of feedback. And this got me into some trouble. I came on the bench, and I was, I gave one of my colleagues some feedback, and when you post to the panel, it also goes to the clerks of the panel members. And one day I was at my desk, and I look up, and my clerk has appeared at the door, green in the face. And I said, "Yes, Matt, what's up?" And he said, "Did you see Judge so-and-so's comment?" And I turned and I looked at my computer, and the judge was mad. Something like, I can't believe the audacity to comment on such and such and such and such. I just laughed, and I called my colleague and said, I come from academia, I'm not doing my job, but, this is what's important to me, and let's talk about it. But, I think the culture is a contribution of many people. And, I personally appreciate more engagement. I feel like you're the only other two people on the planet who have thought about this from the perspective of a court as deeply as I have. Can you please, engage? But other people feel like it's insulting. It's not, I'm doing my job. Where do you get off? But I also learned sort of incidentally from a different colleague who said, oh, just because you join the opinion doesn't mean you agree with everything in it. And I thought, oh, bingo, that's how you can sign on to an opinion when you don't agree with everything in it. So then the question becomes, well, what's dictum and what's holding? And I thought, boy, I wish I knew when I was a student and a practitioner why that difference can be considered so important. If it's coming out of a court where the judges are saying whatever the author wants to write, as long as the holding is one I agree with, well, then that dictum is a lot less authoritative than if it's coming out of a court where people are acting like, Professor Pillard and really wanting to only sign on to what they agree with. And, and I believe me, I've signed on to plenty of things where I didn't agree with every part of it, because that's the nature of the multi-member court.
Yes, so why don't we come over here, and then we'll go over there. Yes, please, sir.
Thinking about the public perception of the court, I know Justice Roberts, people say, thinks about the public perception of his court a lot more than previous chiefs. And you see on the New York Times some of your opinions. The PDFs are posted there for the public to look at. But at the same time, we think of judges as, they're not political. It's not a political branch that you serve on. So how do you think about the public perception of your court? And do you ever really see yourself, when you're writing an opinion, do you see yourself talking to the public? Do you think about how non-lawyers or even, non-specialists will think about your cases, what you have to say?
I do think about it, and something that I try to do, but I don't implement this regularly as I should. There are some judges who are very good at writing an opening paragraph that is a great summary of both kind of the capsule summary of what the facts are of the case, and what the issue is, a core issue that's being presented, and how it's being resolved, and why we are resolving it in that fashion. That's something that's very hard to do, and I'll just confess that sometimes I just don't always take the time or feel like I have the time to really pour into something like that. But it's important because I think, especially in this information age that we live in, we are speaking more directly to the public because they can download our opinions within 5 minutes after we issue them than in prior generations. And people are a lot more savvy and sophisticated now. And having something like that in the opinion, either at the beginning or the end, I think is very helpful for the public and for the press and others who are trying to understand and explain and communicate what we're doing. And I think that we do need to be cognizant of preserving the goodwill that we have with the American people and our stature and the confidence that people have in our branch.
I think about all the different audiences that will be reading the opinion when I'm writing the opinion, and so the affected parties, of course, the parties to the case, future affected parties, lower court judges who will have to follow our opinion, future panels of our court, the Supreme Court, in case they review that particular case. I'm thinking about them. I want them to pick it up and say they get it. I want the academic community to understand it, the public at large to understand it. And what I'm looking for is obviously to explain the law as clearly as I possibly can and to write and rewrite until I can do that. I'm also looking for the losing party, or the party that hates the result that I've reached, to at least be able to say, he gets it. I hate how he resolved it, but he gets it. He understood the issue. He grappled with it. And so I'm looking to do that in my opinions, and I think that's an important value for the losing party in the case. This is also true at oral argument, to make them feel like they got a voice and actually give them the voice. It's not just appearances, it's reality. But in the opinion, I want the losing party to think they got a fair shake, and that's very important. So I'm thinking about all those audiences simultaneously when I'm writing an opinion, and that can make it challenging, to Robert's point, about trying to convey it as clearly as possible.
I really liked when you were saying, do you even think about non-lawyers? Because one piece of advice I used to give to students and then I give to clerks and I try to follow myself is this something that, Uncle Cedric could read and understand? And my first summer, after I had been sitting for a few months, I went up to visit my dad in a break in the summer, and I brought a folder with all my opinions, and it was so hilarious because he actually read them and he was talking to me about them. And so I think, I have to say two things about the legacy as an opinion writer of Justice Scalia. He really brought clarity of opinion writing to a new level, and I have to say that we new judges, aspire. I have to say Judge Kavanaugh is a wonderful opinion writer who takes that clarity, that tradition, and really manifests it in the work that he does. I think clarity is really important. I would say, though, that I'm quite critical of another aspect of Justice Scalia's legacy as an opinion writer, which is the snarky, sort of low blow for laughs. I think it's really problematic when judges try to be cute, try to be clever, and certainly when they do it at the expense of either colleagues or a party. It is an extremely serious business that we're in, and I think Brett gets it exactly right when he says that the confidence in the judiciary and our ability to play a constructive role in our government is greatly affected by how the people who are coming away without their favored result feel about the process. And we're really not doing our job if we don't leave people with the sense that we've given them honestly and comprehensively the real reasons for our opinions, and that we've done it in a way that really respects the stakes that all parties have. And that is such a pleasure to be trying to, but it's a lifelong project to try to get there where you can actually write something that's readable and that's clear and that really gives the process the dignity that it deserves. I would also say one other thing about when we think about the public, and this varies, I think, among Court of Appeals judges. We're a multi-member court, and I have become increasingly motivated in my time on the bench to reach a unanimous opinion when we can. And that, when you talk about what's hard about the job, deciding, I come into something, I have, a view of it, it's pretty confident. I find out at conference that I have two colleagues who disagree. And I have a decision to make there. How important is this to me? Is there a path that they would agree to that I could feel I could stand? Is this, in what is to be gained from writing a dissent? I certainly think something's to be lost. I think that the constantly riven panels make the public think, well, the law is not one thing. And you're lawyers. You wouldn't have a profession if the law were really mechanically one thing. But at the same time, I think we really owe it to people. It's like there's actually, I think about this. I was on a jury in D.C. some years ago, and we deliberated for a long time, and we couldn't come at first to a verdict. And we had what's called an Allen charge. We went back to the courtroom, and the judge read to us, this is a charge based after this case, United States versus Allen is an 1896 case where there was a deadlocked jury. And so the judge says to the jurors, try harder. And I think about this when I'm working with my colleagues, because the substance of it is fantastic, and I'm going to make it as if it's to judges. If you are outnumbered, you should reconsider whether your doubt is a reasonable one, since it appears to make no effective impression on the minds of the others. If you are in the majority, then your colleague who are holding out should ask himself or herself again and most thoughtfully whether she should accept that which fails to convince her fellow judges. And the last part of the charge says, you're not expected to give up an honest belief that you may have, but you have a duty to agree if you can. Right? So this is telling jurors, break your deadlock. And I think that's a really great instruction also for Court of Appeals judges to think, okay, you don't have to give up an honest belief, but you have a duty to agree if you can. And so just sort of, figuring that out is tough. And sometimes, Brett and I have talked about this, sometimes you don't write a dissent, and later you think, that was the one where I should have done it. And other times you think, well, I really sweated that one. Why did I, who cares? Yeah. But, and then there are other times when I'll be reading, here's a dissent on a panel from another circuit. And I'll think, it wasn't, yes, this is a close issue, and that might become the majority in our court. So there are some good reasons to write dissents, but when we think about the public, at large, and what are we doing, and how is our product received, I think that whole question about the quest for unanimity, for me anyway, is part of what's going on.
So I promised that I would go over to this side, and so, yes?
First of all, thank you three all so much for being here, for taking the time to come celebrate and to speak with us. I have a question that I am sure is on the minds of a lot of my fellow classmates, which is what are some of the characteristics that really make a clerk stand out as a really exceptional clerk?
Law clerks.
Let's see. I think, we're blessed with, these brilliant people who come to us with an abundance of talents. And so just trying to figure out what makes, one special, or what makes a really good clerk. Obviously, we're relying upon our clerks for their analytical ability, and also to a large degree their writing ability. And so, the clerks who to me have been my best clerks are ones who really excel in that fashion, who really can help me think through how best to analyze this case, because as Nina was saying, we have to figure out how we can navigate and get to, get to 2 and hopefully 3 votes and write something that everyone can agree with and keep everyone on the bandwagon, so to speak. And so really figuring out analytically how to navigate the landmines is important, and obviously also being a strong writer.
One thing I'm looking for is people that are different from me. And it's funny because when I became a judge, I got all these letters of recommendation from former colleagues in academia who would say, oh, you'll like this person. She has a civil rights background. She's, wants to do women's rights work. And I'm like, I got that covered. How about some, national security, somebody who's into environmental law? I often really like to have somebody who's done work on Wall Street, who has an economics background. I had one clerk once who had been a chemistry major undergrad, and we had an environmental case, and we were trying to figure out something about the use of a liquid bath for purposes of diminishing vapors, and it was unbelievable. It was like I couldn't figure out why surface tension was important, but we had a whole conversation in chambers, and we could have decided the case without that, but it just, part of my quest to really know what's going on makes me want to have people who have different intellectual interests, but also different life experiences. I really looking for people who are different to me and not ideologically homogenous, not going the same place, but there's also some self-selection that goes on, frankly. I do think that we get slightly different pools because, people are motivated to work for people that they style themselves on. But and judgment, people who are a little bit, have other life experiences, have done other things, is a huge plus.
As briefly as I can, because I could talk for about 5 hours about that question, and I would like to, but I won't. I said the favorite part of the job was oral argument in terms of the mechanics of the job. My favorite part of being a judge is relationships with the law clerks, undeniably. It's fantastic. And
oh, come on, Brett, you like us too.
yes, and my colleagues. Yes, and my colleagues too. Yes, of course. But the ability to have a year to spend with 4 people who've done well in law school and have this ability to do great things in the future and to have this opportunity, and I actually view it more as a responsibility, actually. It's like the professors here, your great professors here, who teach you, and I have this responsibility to do it to 4 people for 1 year and to have a huge influence on them the same way my judges had on me. And so I take it very seriously in terms of the responsibility that I have, and I'm looking for people who have the talent and ability, and we do the best we can in assessing the character, the personality fit. I don't want people with sharp elbows. I'm not looking for that. But also a desire to do things in the future that involve public service, and making the country a better place, and someone who sees, and I can play some small part in that. Like Anina said, I'm looking for people different from me. I've had more women clerks than men clerks in my 11 years. I've spoken to a lot of, I've had a lot of clerks who have different judicial philosophy or political background than I had, including at the moment. And that's been part of what I share Nina's view on that. Just this year, I have clerks that span the spectrum from kind of pretty wide spectrum, and that's been very valuable to me to hear those different perspectives on some complicated cases we have. So that's important. But overall, I love the relationships with them. It's great, and I feel it is a huge responsibility, and so I take it just unbelievably seriously because I know it's also an opportunity from the student end to be on our court. So
I would say one other thing about it, and this is something to think about if you're temperamentally more suited to clerk in district court or court of appeals. I know a lot of people do both, and they really challenge different parts of your sort of lawyerly skill set. and Robert really summed it up when he was talking about the district judge role versus the Court of Appeals role. I have right now 3 clerks out of my 4 who have clerked for district court, and sometimes I feel like they're still in the mode of like, okay, there's the right answer, done. And this is not what we do. This is not what we do. It's all about, can you continue to sort of keep the skein unraveling until you get down to the last level you finally can. You really want to get it right. And so I once had someone actually who interviewed herself out of a job. I was all but ready to hire this applicant, and I asked, if you were pressed, to identify a weakness, what would you say it is? And this person said, well, I think when I come to a decision, then I tend to, I'm very efficient and I move on. And sometimes maybe I'm a little too confident in my own decisions. And I thought, that is not what I need.
Remember that, everybody.
Yeah. There you go. That's
Perseverate.
Yes, so you've had your hand.
Keep your finger down.
hold it.
Okay.
No, it's not working.
At the base of it. I think.
There you go. Yeah,
Okay, got it. So, thank you. What you have described, each in your own way, is the life of an appellate judge, which is very isolated. Judge Kavanaugh, you talked about a day that consists of reading briefs and writing opinions and considering a draft opinion from a colleague. And Judge Pillard, you talked about experience, and we know many great legal minds have said the law is greatly influenced by experience, but you talked about prior experiences before coming to the bench. And Judge Wilkins, of course, you were both a district court judge. A district court judge deals with jurors and counsel and witnesses and a lot of interaction there. Appellate judge is very, very different. And there are restrictions on what you can do in terms of joining organizations and that kind of involvement. So, not that any of this startles me, because I've always thought that would be an issue for appellate judges, but how do you deal with that kind of intellectual and philosophical isolation?
The day I was confirmed, the day President Bush signed my commission, which was May 30, 2006 at 7 a.m., not that you forget that, I went up to the Supreme Court, and my former boss, Justice Kennedy, swore me in his chambers with just my family there, and the Chief Justice came, and that was it. And then he sat me down and my family down. He said, you're going to go over to your chambers on the D.C. Circuit, and they're going to give you a phone and a computer, and no one's going to ever call you again. And what he told me at that moment, he said, he said, you're young, at the time I was at least, teach, you need to get out and speak, you need to go to events, bar events, you need to be out in the community or you're going to find yourself really straining. And he had done that. He's taught every summer the whole time he's been a judge. That's why I talked 2 days after that to then Professor Manning, still Professor Manning, but now Dean Manning, and he talked to Dean Kagan and arranged for teaching, and so I started teaching right soon after that and kept that up. Why I like being at these events, so you have to, I think, you'll go, I coach 6th grade basketball. I actually obsess about that a lot too. So you got to do things outside of just, or you will kind of lose it after a certain point, I think. The second thing about the isolation of the job, I love the clerk relationship, and Nina alluded to this, the satisfaction you have in terms of, or enjoyment, I should say, the enjoyment of your job is going to depend a lot on your colleagues. And in our line of work, you don't get to pick your colleagues. The President and the Senate pick your colleagues, so you're always holding your breath when you get new colleagues. How's this going to fit in? And as one of my colleagues likes to say, one of my older colleagues, the older you get, the more like yourself you get, which he did not mean as a compliment. So I will just say, it's luck of the draw, but I'm just going to say this because I think it's important to say. I consider myself very, very lucky to be on the court I am because of the cases we get, the responsibility we have, but the colleagues I have are really tremendous in terms of not just their intellect, but you can tell from this panel today, their thoughtfulness, their friendliness, their willingness to work together with each other, with me, and me with them. Hopefully, I'm a sinner on all of this, but I try to do my best when I can and all the time. And that makes a huge difference. And I'm lucky. And we disagree on cases. Certainly, that's where we're not supposed to always agree, as Nina pointed out. But we do disagree. But Judge Ed Becker on the Third Circuit liked to say, yeah, you're supposed to disagree, but when the case ends, you say next case. You don't kind of let the past case control how you're going to view the next case or ruin relationships on the court. And I'll just say, because since they're the newer colleagues, I consider myself very lucky with my newer colleagues on the court and with the colleagues who were there when I got there, who welcomed me even when I was young and writing separately too much.
I second everything that Brett said. One of the things that I once heard a very wise lawyer say something as a kind of offhand, as if everybody knew this, that, one of the professional characteristics of lawyers is that they know how to talk and disagree about very, very important things about which people, including we lawyers, feel very passionately without personalizing. And I thought, yes, that is one of the things that I think is extremely important, and that is something that lawyers can personify. It is not something that lawyers always personify, or judges always personify, but just being able to think about that it is not in derogation of the seriousness of your commitment to something to nonetheless be decent and appreciate and have fun with and the people who you disagree with. And I just consider that to be one of the most exciting parts about being on the court that I'm on, is that we have a real genuine range of different takes on a lot of things, and that we do really work together constructively, deeply, and that we really do enjoy one another. It's just I find that to be really important, really moving, and I'm really, privileged to be part of that. In terms of how do you stand the isolation, it's so funny because the White House counsel, when I was interviewing, said, are you ready for this? This is a really isolated job. And I thought, I'm a law professor. I teach my classes alone. I write my articles alone. I don't have any staff. And it's like a piece of cake. It's not going to be any different. And it is really different. It is really different. You just can't talk to people about what you're thinking about. And when you're a law professor, you're constantly talking to people about what you're thinking about. And so the clerks are really important. But I also think that people outside the field are really important. I have a group of friends, several of whom have nothing to do with the law, and reading outside the law I find to be really helpful. Volunteer work with people, again, who are really different to me, is something that I feel like, keeps perspective, keeps my feet on the ground. But yeah, it is isolating. It's also really striking how certain people stop calling because they just feel like, she's a judge, I can't call. And other people, suddenly you're their best friend and you were just an acquaintance before. So it has an impact on our gregariousness. And so it is a bit of a...
Judge Wilkins gets the last word here.
I think that it is hard, and I think I would, go bonkers if I didn't have some outside interests and friends who were non-lawyers that I could, engage with, and just have an ability to both, have some human interaction, but also to be able to put the job aside for a while, which I think is very important. But I also think that it's important to find the way to engage with the legal community as much as possible outside of the court setting. In part, I guess it's the part of me that's the realist. You know, I'm very concerned and try to be cognizant of you know, the real impact of our work, and so there's really, it's hard to really be on top of that if you're not out and talking to people and reading you know, some of the commentary, not all of it, but some of the commentary out there about what the courts are doing. Because you know, I think that we can't be siloed. I don't think that we can do our job as effectively as we should if we are siloed.
So I want to take a moment and say thank you to this very, very distinguished panel of judges. Thank you very much for the candid and wonderful, interesting conversation.